so let's get on the record and I will call the case and we will go forward from there. Yes.
Your Honor, I just want to clarify, would you like me to stay muted and my video on or off while Mr. Ragnar presents his case?
Oh, thank you for asking. If you could mute your audio, that would be great. Thank you.
Wait, I'm sorry, I couldn't hear.
Okay, I'm going to call the case now so that everybody knows what we're doing here. We are here for a single justice hearing of Salem Housing Authority versus Ragnar, case number 22J390 in the single justice session. This is a review of the summary process and appeal bond and use and occupancy order from the housing court. The docket below was 21 SP 2679, and each party will have 15 minutes to present its case. I am Justice Rachel Hershfang. I use she and her as my pronouns. I would be grateful if each of you would identify your preferred pronouns when you begin speaking so that I can correctly use the pronouns that you feel are appropriate for you. The petitioner goes first, so I will hear from you.
Oh, that's me?
That is you.
As opposed to the plaintiff. Okay, now, I didn't understand that. Did you say that this is a single justice hearing on the second notice of appeal or the first?
This is a hearing to determine under General Laws, Chapter 239, Section 5G, whether the order that was entered by the housing court, which was that you have a $200 bond that was to be paid by July 15, and that you were to continue to pay your use and occupancy. It's a review of whether that was correctly entered. So that is what we're doing here today.
Oh, okay, because when you said summary process, I thought, but you might be throwing in the first notice of appeal there, which of course I'm not prepared for either one of these because I can't do it over the phone.
Well, there are some questions that would be helpful to the court to have answered. So if we could start with that, that would be really helpful to me in doing my job. Is that okay? And do you, what is your preferred pronoun? How would you like me to address you?
Ragnar.
Okay, no Mr., Ms., just Ragnar.
No, that's what everybody calls me.
Okay.
Ragnar, I don't know if you're familiar with the name. It's Norse. You know, it's more if you were like Sven, Ole, Nels, Hans, and stuff like this. Are Scandinavian names, and they're common and known to people here. But like if you were to go to Norway, Iceland, Sweden, Denmark, you know, my name is more common there than all the other ones put together are here.
I understand. Okay, sorry. I'm sorry to cut you off because that's interesting, but I'm also mindful that your clock is ticking and I don't want you to use time that you might want for something more substantive. So one thing I would like to know, Ragnar, that would be helpful to me is what is your current monthly rent payment in your current housing?
That comes out of my check?
Yes.
Okay. DTA pays out of the money I get from EAEDC. Okay, DTA pays them $100 million.
I'm sorry, did you say 109?
Yeah.
Okay, thank you. Sorry, I just couldn't hear that last number. And are you current on that rent right now?
Yeah, DTA is paying it.
Okay.
And they are committing fraud, okay, by telling DTA that the living conditions are habitable, and then here they are saying they're not.
All right, I want to refocus you on what we're doing here because I want to make sure that we can get the information we need. Okay, so it's really helpful to me to know that you're current on your rent And
Mhm.
the other piece that you would need to establish that was not established in the housing court because apparently you didn't appear is what your issues are on appeal. So it would be very helpful if you could just summarize for me what you are appealing.
Okay, in the first place, I was there. In the overriding issue is that the state legislature got together and said under 760 Code of Massachusetts Regulation 606, parentheses 8, parentheses small a, parentheses small b, that until I have a grievance hearing, they can't file this in Northeast Housing Court.
Okay,
Their
so
violation of the process.
okay, so your first issue is that you believe you are entitled to a grievance hearing before this summary
Yes.
process started.
Yes.
Okay, all right, that's very helpful. Do you have other issues that you were planning to appeal?
Well, again, the things that I have wanted to show you in person, if you had wanted to see it, is that that the plaintiff has engaged in one lie after another in perpetrating a fraud on the court, and that was entered in that sham ruling that the judgment that the judge had made. And he at least got that entered in there, that I had said they were perpetrating a fraud on the court. And I had been warning them of that for a long, long time. So there
Okay,
I was.
you know, it's really helpful to me to hear not just the conclusion. So the conclusion would be there's fraud on the court, but I need to hear a little more about the allegations. So if you could describe for me one or two of the things that you claimed below, not new claims, because that's not what we do here at the appeals court, but are there particular things you identified in the proceedings before this that you say were fraudulent?
If a judge, okay, is not allowed to hear a case, and if in trying to force the judge, to follow the law, you have to file a case against him under Title 42, Section 1983 of the United States Code. The judges really don't want you to file against a judge. So that I was always trying to keep the judge out of it so that he wouldn't be wrapped up as a defendant in that type of a case. Okay, so that I never had a chance to talk, to enter anything in. You know, nothing. Got no due process here anywhere.
So when you talk about the plaintiff, in your words, engaging in a fraud on the court, what is
Yeah.
it that you say the plaintiff did?
Well, again, they've done so much that for me to try to get that information to show you that over the phone is no, that's part of the evidence that if Your Honor had wanted to see it, I would be showing you.
So I guess part of the challenge here, and I apologize, I promised you a 10-minute warning. We're now at 7.5 minutes. So I dropped the ball on that one, for which I apologize. But what the appeals court does is review things that trial courts have done. And so we are not, either individually or as a group, we are not a court that sees evidence, new evidence for the first time. We are a court that sees evidence that has been entered and admitted in earlier proceedings. So if the things that you wanted to show me are not things that are part of the record, they're not things I'm allowed to look at. That's the way that the jurisdiction of the court is. Just that's not what we're allowed to do.
Nope.
Okay, I don't understand what you're saying no to.
Things I want to show you are part of the record.
Okay, so the record that I have here is a record from the housing court, and It is, sorry, I'm looking over to the side because that's where my other screen is. It appears to be 47 pages long. Do you have a copy of that record, Ragnar?
No, all I've got is, well, I mean, I have the papers, of course, that I filed, and I have some of the papers that SHA has filed, Salem Housing Authority has filed, you know, but no, I don't have everything. And also, in addition to that, the whole thing with the docket numbers, there's a lot of substantial errors, non-truths, misstatements, misrepresentations, and outlines that will show up on it, which is, again, why I had wanted to try to make things easy so I could walk in. And then, you know, Julia told me you got 15 minutes. You know, should warn me about that. So that, you know, within 15 minutes, I could just hand you the stuff as fast, you know, as fast as you could ask for it. I could just reach down and pick it up and hand it to you.
Well, I don't want you to feel like you've missed an opportunity here, because the only thing that we are doing today is what I mentioned before. So I am looking at this decision from the housing court and deciding whether or not your appeal should be able to go forward without your paying the $200 bond. And so there are two pieces to that. I need to determine that you are indigent. I am satisfied by what you have told me today that you are indigent, and I will ask Attorney Jean Felix when it's her turn, and we have 5 minutes left, to tell me whether she agrees with that, because I'm interested, not because it will make my mind up for me. And then the other piece is whether you have what's called non-frivolous, which, you know, is sort of lawyer speak for it's not ridiculous, right? Argument to make on appeal. I'm sorry? I'm having some...
Stated in the case, it's not a prayer of a chance.
Okay, so that's maybe one way of expressing it. And so that's why I'm asking you about your appeal issues. Hold on one sec, Ragnar, because I'm still speaking and I want to make sure we can hear each other, okay? That's okay. The reason I'm asking you about your issues on appeal is not because I am going to decide them. That's not what I do here, right? But I'm trying to make sure that you are afforded all of the rights that you are due under the law to pursue your claims. And so part of that is making sure that I have the information I need to determine whether your claims are non-frivolous. So you've told me about two things so far. And I just want to make sure, because we only have about 3.5 minutes left, that you tell me about any other claims that you raised in the trial court and that you are hoping to pursue in your appeal. Are there additional claims?
Yes, there are, and I cannot do that in a short period of time, nor can I do that without handing you the evidence that is there for you to examine over the pages. In addition to that, how can we rule on something that a judge has ruled on when the judge can't even hear the case?
I'm not sure what you mean by the judge can't hear the case. Are you saying that there's a jurisdictional problem here because you didn't have your grievance hearing?
The due process there is constituted by the state legislature, who said you must have a grievance hearing. And then with the grievance hearing, the panel decides, yes, housing can go forward and take it to court. No, they can't take it to court. And that's never happened. They've denied me that knowingly.
Okay. I heard you on that. And I have made notes that is one of your issues that you want to pursue on appeal. To the extent that you can give me a headline for any other issues, that would be helpful. I mean, I will note that lawyers go to the United States Supreme Court and argue their case, and they don't bring a stick of evidence. So it is possible to describe your argument without showing things.
I'm not at that caliber that I have that kind of ability.
Oh, don't sell yourself short.
You know, in front of the Supreme Court with nothing to show, that would be, I mean, the whole thing would be scary as hell.
I agree. It'd be scary for me too. Okay, so So you've mentioned two things. Is there anything else? You've got about a minute and a half left. I just want to make sure that I hear all of the issues that you can describe for me on this during this hearing.
Again, if you could extend the time, since a lot of, sorry, Your Honor, but a lot of this time you've been helping me. I haven't been able to speak, of course, but that just to give you an idea on how bad it is with this judge, who I think by now is biased or anything. I've heard things in the courthouse. But anyway, is that they had been doing all of their meetings by Zoom, okay, which of course I can't do because I don't know computers. But anyway, they had been doing all of their meetings by Zoom. On June, 16th, I had literally been in the courthouse so they could put me on the computer on Zoom. The young lady there who's with you and a lawyer of the day who was sitting in as an advisor, okay, ended up then saying, well, let's reschedule this hearing for 2 weeks from now, June 30th, and while we're trying to work out a settlement agreement, okay? And, you know, of course, I acceded to that. And then after that, at the tail end of the meeting, they had said that, okay, now, again, it's going to be another Zoom meeting on June 30th at 9 o'clock or whatever it was. Now, I have a lot of health issues, okay, which nobody seems to care about, but I have a lot of health issues, and I was really, really sick on June 30th. But nonetheless, of course, you know, to get the call in, I was trying to get the call in, but the numbers weren't working. I had to use old numbers because I couldn't find the new sheet of paper, which it turns out was never sent to me, okay, for the June 30th hearing. And then when I finally got a hold of a real nice young lady in Lawrence, because that's the only number I could find to get a hold of somebody in Northeast Housing Court, you know, she says, well, it's listed as being in person. I said, in person? What do you mean in person? They're not holding in-person meetings. Okay, and then later I came to find out that, yeah, they changed 2 days before on the 28th and started doing them in person. Okay, of course, nobody bothered to tell me or show me anything, but plus we've been having troubles with the mail, okay, to begin with. But anyway, so then after that, then I got together, sick as I was, and I got my files together and, you know, paperwork together and stuff like this, and trotted down to the courthouse to say, hey, listen, I'm here, you know, here's what happened. Well, I'd already talked, you know, besides talking to Lawrence gave me the number for the Salem Northeast Housing Court. Then I called there and told them that, but they said they couldn't, you know, do anything. So then after that, then when I came in, the judge was on a break or whatever, and then he came back out, and you know, the clerk there sits next to the judge says, you know, well, you know, he's got to take these other cases. Like, he's going to take me after that or what? He says, no, he says, you know, go downstairs and you know, file these extra motions that you want to file down there. I said, well, okay, but let's make sure he knows that I was here. Notice none of that shows up on the order you wrote. But anyway, so then after that, then I run down, you know, to the clerk's office to put these motions together, like getting, since it's all done by computers when they're trying to get for the record, since it's all done by computers, I can't get that done either. They said they're going to have to talk to the judge to have him do it or have his office do it. And so then I was working with that. And then outside of there, the housing specialist comes out and says that she just got a call from the judge's clerk that says, well, you know, you can go ahead and file your motions, but we would advise that you don't until the judge files his. Okay, now remember, this is still before noon on June 30th, okay? And then after that, then I said, you know, they said it to me a few times. I said, well, you know, I guess okay. And so since the mail wasn't coming in, every single day around 4 o'clock, I would call Salem housing court to see if, in fact, the judge would rule on it. Well, he didn't rule on it on the 1st. Then we had the weekend of the 4th. He didn't rule on it Tuesday. He didn't rule on it Wednesday. He didn't rule on it Thursday. And then Friday, just before they closed, they said that, yes, they got the ruling back from him. But he backdated the ruling until June 30th. Okay? And yet he didn't post this bond thing of the $200 until that Friday, the 8th. Okay. Now, your staff, on the other hand, in informing me of this Zoom meeting that we're one of us is having now, you know, and the other's on the phone. But with this, your staff has sent 2 letters, has sent like 4 texts, and about 4 to 6 phone calls to make sure that we were on the right page. Oh, and the last one came yesterday. That's how efficient you guys are.
Well, I would like to say that I agree with you that we have an excellent clerk's office, and I'm glad that they have been able to reach you about this hearing. And Ragnar, I apologize, but you are now many minutes over your time limit. I have heard you on your issues. That's been very helpful to me. And now I'm going to turn it over to Attorney Jean Felix for 15 minutes, if we need that long. And I appreciate your input. All right, Attorney Jean Felix.
Do I get a rebuttal?
I'm sorry?
Do I get a rebuttal?
No.
Thank you, Your Honor. May I proceed?
You may.
Good morning, Your Honor. So first and foremost, I would respond to your question earlier. The respondent does not question whether or not Mr. Ragnar is indigent at this time. He is a tenant of the housing authority, and we understand that means may be limited. So I wanted to address that point first and foremost. The respondent's position also is today that this appeal should be rejected and is not properly before the court. We understand that Mr. Ragnar is arguing this and following the process here pro se and does not understand necessarily the procedures, but we were left to surmise what he was appealing, as we did not even receive a copy of what was being appealed before to Your Honor today. And so this is my first opportunity to hear his points of contentions and issues with the court. We were also under the impression that he was appealing the order that entered, which allowed the motion for entry of judgment, which was filed with the court and duly approved by the court in May. So with that said, I will address the points that he has made today. So specifically, Mr. Ragnar fails to establish, as is his burden, that the trial court committed an error of law. There was no error of law which was committed by the trial court. He had an opportunity to be heard on the prior hearing, which was scheduled for June 15th. When it was continued to the 30th, it was made clear that the parties were to appear in person before the court for the continuation of the hearing for Mr. Ragnar's request for bond. Mr. Ragnar failed to appear, and the court properly entered the order against him to pay, that he be charged with paying bond for $200 and by July 15th. Mr. Ragnar failed to do so, and as such, he should not be afforded the right to review, to the extent that the court may want to recognize that he is indigent and would like to proceed with these reviewing his petition. It also should be noted that this matter is still not properly before the court, as there still, as it pertains to his other issues that he's raised, the respondent properly served him with a notice to quit. Just by way of background, a notice to quit was served on Mr. Ragnar in January 28, of 2021. And as you'll know in the docket, the case was not filed with the housing court until September 1st, 2021. And during that time, the parties did afford Mr. Ragnar his grievance procedure. The parties had a hearing, engaged in extensive negotiations to come to an agreement outside of court prior to filing the case with the court in September. So for several months, Mr. Ragnar was afforded the opportunity to come to an agreement with the housing authority that would facilitate moving him to another unit so that they can make repairs into his unit, his current unit, and eventually transfer him back to his current unit. Due to the failed negotiations during that time, the housing court was left no choice but to move forward with the summary process action for cause. And otherwise, by way of background, the parties entered into an agreement, a stipulation, I should say, on November 2nd, 2021, in which the parties agreed that Mr. Ragnar would transfer to a new unit by December 31st, 2021, and work with North Shore Elder Services to facilitate the process. During that time, he was also afforded the ability to extend the time if needed, as long as he's provided notice to my client by January 31st, 2022. That additional time would be needed to accommodate the transfer to the new unit. Mr. Ragnar had the assistance of counsel and coming to this agreement. The agreement was duly reviewed by a housing specialist, Ms. Capotes, and later approved by Judge Mitchell Munavar. And he was unequivocally represented and had the advice of counsel in coming into that agreement with the respondent. And he unequivocally failed to comply with that agreement when he failed to transfer to the unit and or cooperate with elder services in any form to restore the unit into habitable conditions. So our understanding is that Mr. Ragnar is seeking to appeal that order, that the motion was allowed on the grounds that that my client committed fraud on the court. As I pointed out, there was no fraud committed on the court. The client afforded Mr. Ragnar his grievance process. He was afforded the opportunity to do an agreement outside of court. He also was given further right to recourse by having the agreement reviewed and advised with the advice of counsel and entered into, and he still to this day refuses to comply with the terms of this agreement and currently occupies the unit, which remains in a very inhabitable condition. He's also failing to give my client access to the unit to allow my client to make the necessary repairs. So to the extent that Boston Housing Authority versus Casio, which is cited at 428 Mass 112, mandates, right, the fact that Mr. Ragnar failed to comply with the terms of the stipulation was proper grounds for judgment to enter and the execution to issue from there. And this also tracks well with Mass General Laws, Chapter 239, Section 10, which also further states that in considering a motion for entry of judgment and or an issuance of execution, that the court shall determine whether the tenant was in violation of the terms of the stipulation of the parties, which is the case here, Your Honor. Mr. Ragnar has failed to abide by the terms of the agreement. Further, pursuant to Planned Parenthood versus Operation Rescue, which is cited at 406 Mass 701 from 1990, Mr. Ragnar is burdened with proving that the trial court committed error of law in entering either order, whether it be the order allowing the plaintiff's motion for entry of judgment and issuance of the execution, or the order entering requesting that he pay bond so that he may be heard for his hearing. There's no error. The judge properly followed the standard set by the law. And Mr. Ragnar has failed to show that the trial court committed error before you today, Your Honor.
Is there, I saw on the docket the information about the stipulation and the terms of that, so it's helpful to hear that again. Is there I'm asking you this while I'm looking, is there a signed stipulation in the record?
Yes, Your Honor. It that stipulation was
On
signed,
Page 28, yes, okay. I see
it was
page
signed in,
27.
I believe on November
Second, it looks like.
2nd, 2021.
Okay,
And it was signed by all parties, including his counsel.
okay. All right, thank you. That's helpful. Is there anything else you'd like to pass along, Attorney Jean Felix?
I believe this covers the issues that we surmise that Mr. Ragnar is raising before the court today. I mean, Mr. Ragnar failed to avail himself to the course of.
Can't speak for me, Your Honor.
I'm sorry, it's now Attorney Jean Felix's time, and I would ask you to please
Objection. She
give her the
cannot speak.
respect that she gave you and let her have her time. Thank you.
Thank you. So, I mean, the respondent's position is that he failed to avail himself to, legal recourse by failing to appear for his hearing on his request to appeal his bond, to waive his bond. And furthermore, today, he failed to establish that there was any error of law committed by the court.
Okay, thank you very much for that. Thank you both. It's been very helpful to hear from each of you on your positions. The matter will be taken under advisement, and I thank you both for your time. Wish you a lovely day, and you will hear from the court.
Sorry, Your Honor, if I spoke out of turn, but you had made it clear that a rebuttal, that you can't do rebuttals, but you didn't say anything about objections.
Okay, that is a technical point that I hear you on. And yes, the practice in the appeals court is that unfortunately, when you are hearing something that you disagree with, you are required to just sit there quietly. So
because this is why I wanted to be able to hand over evidence to you to show that, she's now carried the fraud over to you.
okay, there is no rebuttal, Ragnar, so I apologize, but I'm going to have to cut you off, and I will look carefully at the record, and I will carefully consider the information and argument that both of you have made, which I appreciate, and the hearing is now concluded.
I'm sorry, Your Honor, but I'm under a little bit of pressure here.